What if your boss was on his deathbed, handed you the keys to the house, said, "Everything in here is yours"? But the court still said, "Actually, oh, no it's not"? Welcome to Newman vs. Bost. We have deathbed drama and the gift that didn't count. Today's case had the court looking at the question, what kind of delivery is required for a gift made in contemplation of death? This is 99 Rights, online, where we turn legal chaos into clarity. And today we're diving into the OG drama of gifts Causa Mortis. Before we get messy, let's get basic. A gift is a voluntary transfer of property with no payment, no trade, no Venmo me later. Unlike contracts, there's no offerer or offeree, just a donor giving something and a donee receiving it. Gifts, plus generosity. Contracts, chas capitalism. There are two flavors. 1. Inter vivos gifts, given while the donor is alive. Once made, irrevocable, no takebacks. 2. Gifts Causa Mortis, given when the donor thinks death is knocking. If they survive, gift revoked. It's basically the just in case I die category of property law. To make any gift stick, you need the Holy Trinity. 1. Donative intent. 2. Delivery. 3. Acceptance. Donative intent. This is the I want you to have this now. Delivery. You must. Hand it over or deliver it constructively if you can't. Acceptance. The general rule is usually presumed because who rejects free stuff? But if any element fails, no gift, no title, no exceptions. The year is 1898. Our donor, Mr. Van Pelt, is dying. He is on his deathbed. He hands his housekeeper, Newman, our donee, the keys to the house and says she should have everything in the house. Sounds legit, right? Well, not to the court, because inside that house was a $3,000 life insurance policy. And the court said, "Ma'am, he could have handed you the policy. He didn't. Therefore, no gift." Furniture? Yes. Gift insurance policy? Absolutely not. If an item can be physically handed over, it must be physically handed over. Symbolic delivery is not enough. So what does Newman v. Bost teach us? That if you're on your deathbed and want to give someone something, you better hand it to them like it's a hot potato. Because in gift law, intent is great, but delivery is king. And courts don't do symbolic vibes when the item is literally sitting across the room. Newman got the furniture. She didn't get the life insurance. And the court basically said, if he could have handed it to you, he should have handed it to you. This case is the backbone of gifts Causa Mortis and cemented the rule. If manual delivery is possible, it is required, even on your deathbed. It also teaches that courts hate uncertainty, especially when someone's dead, and relatives are fighting over the leftovers. And it's why gift law is tested constantly in estate disputes. Because everyone suddenly remembers Grandpa said they could have something. So the moral of the story, if you want someone to have something, give it to them while you're alive, or at least physically hand it over before your final breath. And if you're relying on a deathbed gift, you'd better hope the donor didn't pull a Newman vs. Bost and leave the important stuff in a drawer across the room. Because courts don't care about vibes, memories, or he told me I could have it. They care about delivery, and whether your lawyer knows the difference between a valid gift and a tragic, legally useless goodbye present. Lesson learned? Don't die with your gift still in the drawer. Because in property law, good intentions without delivery are just sentimental clutter. And if your lawyer says constructive delivery might work, construct yourself a better lawyer. Like this? Smash that like button, subscribe and follow us on Instagram and YouTube at 99 Rights, online for more legal quickies. Catch ya later. And remember, knowledge is power. Stay informed, stay empowered, and keep fighting for what's right. See you next time. If you found this information helpful and inspiring, don't keep it to yourself. Share it with your friends and family. Thank you.